So, welcome everyone. We are online now. It's our live stream from the European Parliament, in my case, but in many other cases, as you can imagine under today's circumstances, from the offices or home offices of many representatives of civil society, media, and professional unions that we got together today, and we want to discuss one thing that started yesterday, or we entered a new phase, and this is the long negotiated and long expected and long criticized e-evidence procedure, a proposal by the Commission and the Council, and also by the Parliament, the comments by the Parliament, on how to deal with electronic evidence in one European country if there is a procedure or suspicion by state authorities in another European country wanting to get the electronic evidence from an individual in a European, from a service provider, for example, in a neighboring country. I welcome our experts who joined us today from very renowned institutions. I welcome Marco Stefan from Center for European Policy Studies. I welcome Chloe Bartolomé from European Digital Rights, EDRI, from Fair Trials. We have Laure Baudrier-Gérard. I hope I see, yes, welcome as well. European Broadcasting Union, Julie Lenard, Alexander Nietz from the German magazine publishers VDZ, from the ARD, German public broadcaster, we have Jürgen Burggraf. Nice to see you again, Jürgen Burggraf. We have representatives from the professional unions, German Federal Bar, Ulrike Paul, welcome, and from the German Bar Association, DRV, Anna Oemchen, whom I also welcome here. So, ladies and gentlemen, we have just 1 hour live, and we have very concise statements to make. I welcome everyone from the live audience who is online. Just very briefly, yesterday the trilogue started. Trilogue, for our viewers, is a procedure where Parliament and the Council, with participation of the Commission, so the three organs, the three actors of the European Union, will be negotiating the final look like. We have our problems. We had our problems with various drafts, but the first meeting was kind of an exploratory meeting. There was not much happening there yet. The next step will be technical. That means the staff of staffers on all levels will be deciding which points, which topics they want to talk about on the political level with the members of the Parliament. And we will then see how we will be able to defend the Parliament's position, which is more progressive, or whatever you want to call it, than the position of the Council. At least we need to join forces, also those who were against the parliamentarian draft, in order to defend it against the position of the Council, which is more invasive from my personal perspective. Since we only have 1 hour, our viewers, don't be surprised. We have only 3 minutes for each introductory statement or statement by the guests. But let's start right away. In October, CEPS, so Center for European Policy Studies, and Marco Stefan is here, has concluded its report on e-evidence. And not to spoil the outcome, but you, Marco, recommended that the Commission withdraw the proposal. What were the main points of your criticism? You're one of the authors, Marco. Could you please, in 3 minutes, give us a little overview of your points? I know it's a challenge. Welcome.
Yes, thanks, Mr. Lagodinsky. Indeed, I will try to explain why back in October we recommended the Commission to withdraw its e-evidence proposal. I identified 3 main reasons, and I will try to lay out. The first is linked to the fact that we found the proposal incompatible with principles and rule governing EU judicial cooperation in criminal matters. In fact, contrary to existing instrument of mutual recognition in criminal matters, the evidence proposal would not systematically provide for effective judicial protection in both the issuing and executing state. Let's start from the issuing state. There, the proposal would not systematically guarantee peer review by an independent judicial or administrative authority. For instance, for production order targeted subscriber or access data, the proposal does not specify the exact level of independence that issuing prosecutor should have vis-a-vis the executive. It would neither prevent these orders from being issued by prosecutors that, while being responsible for the direction of the pretrial procedure, would also be directing the public prosecutor in the judicial proceeding. And yet, these requirements are increasingly recognized as important precondition for any data request issued for investigating or prosecuting crime to be lawful under EU law. Let's now move to the state of execution. There, judicial authority would no longer be in charge of the legal assessment, validation, and recognition and validation of orders received from other member states. However, this would happen in a context where courts in several EU countries are increasingly challenging the assumption according to which criminal justice measure should be automatically or by default considered compliant with EU fundamental rights and rule of law standards, or with court guarantees provided under national constitutional law. And this takes us to the second reason. We found the proposal likely to increase legal certainty, both for individuals and for service providers. As far as individuals are concerned, the proposal would eliminate substantial and procedural protection under the law of the state of execution. In particular, under the e-evidence proposal, the right that both suspect and accused person, as well as data subject, have to access effective remedies in the state of execution would be curtailed. The only remedy available to individuals in the state of execution would be civil law appeals against the service providers disclosing the data. This type of appeals, however, we found that they don't qualify as effective remedies in criminal justice. Furthermore, the proposal would increase legal certainty for service providers. Providers of internet and telecommunication services could face serious risks of liabilities simply for complying with foreign orders and for doing so in good faith. In fact, the task force discussion have shown that only in presence of a clear obligation for judicial authority in the country of execution to review and validate the foreign order, the legal certainty can be ensured for service provider. Lastly, and this is my last point, we found no evidence of the proposal added value, nor of its necessity and proportionality. In particular, we found no evidence that already existing EU instrument of mutual recognition established for the purpose of collecting electronic evidence across border, and in particular the European Investigation Order, are by design ill-suited for the purpose of intra-EU cross-border data gathering. To the contrary, all the prosecutors that we interviewed in the context of the task force research indicate the cross-border gathering of data under the EAO is gradually improving, working well, and swift enough. So to conclude, I would just like to say that rule and guarantees governing EU judicial cooperation in criminal matters cannot simply be bypassed by framing cross-border access to data as a law enforcement issue. Compliance with these rules and guarantees is in fact necessary to justify the introduction of new instrument of judicial cooperation in criminal matters. Thank you.
Thank you so much. This was already a brief overview of the main points of criticism. Just to make it clear to our viewers, maybe who are not very much in the matter, one of the points that we wanted to focus here is the issue of notification of the executive authority. The goal of the whole exercise is, of course, to make things more effective, to make it possible for one European state authority to get your data in another country. But the problem was that with the proposal of the Commission, and this is kind of one alternative that we will be discussing now during the negotiations, that the so-called executing authorities, so the authority in the state where this data is stored or where the person is situated, is not supposed to be involved in the process. And the question that we, of course, have, and we've been having as a parliament, what happens when, for example, the authorities that wants to get my electronic data is a I don't want to call names, but from a state where we have some problems with the rule of law? What is if this executive order comes from a corrupt a judge or a corrupt state prosecutor? What if there is no sufficiently independent authorities in the country who wants my data? Under those circumstances, if we don't have state authority on the recipient side, on the addressee side, who kind of controls the matter, once again, then the service providers are those who are basically either cannot do anything or must kind of in a private way assess whether this request is okay or not, to put it very simply. So that was our concerns, and they remain furthermore. And we wanted to discuss this also with other members of the civil society. Let's go to Idri, and Chloe is here. European Digital Rights. What is your assessment on what is going on the progress that has been made or not made until now, and where should we go?
Yeah, thank you so much for the invitation. Thank you for having me. EDRI, just quickly, is the voice of 44 organizations in Europe that defend fundamental rights in the digital era. We have been repeatedly voicing our concerns since the very start about the model of so-called direct cooperation put forward by the Commission. And we strongly support the introduction of stronger safeguards for fundamental rights during the trilogues, notably in the form of a notification and validation procedure for relevant authorities. The problems we have with direct effect data production orders from a fundamental rights perspective are numerous. First, with direct effect orders, you ignore EU judicial cooperation principle, as Marco just put it outright, and this gives rise to potential conflicts of laws, which can then have grave consequences for the persons affected. There are 27 different criminal laws in the EU, and there is even a higher number of constitutional judicial protections that differ from one country to the other. And for example, this week we might have one rapper who will likely be put in jail, and he could have well benefited from freedom of speech and artistic freedom protection in another member state than is where he is now. Related to that, with direct effect orders, you cannot detect or stop politically motivated prosecutions and fight abuse in general, which also happen in the EU. You can also not protect individuals with certain immunities and legal privileges. Those immunities exist for a good reason. They are here to protect relations and communication in a democracy, such as between defense lawyers and their clients, doctors and their patients, journalists and their sources, etc. You also limit de facto access to effective remedies, which is a fundamental procedural right. And I leave that to Laura to explain a bit later. Now, the big issue we have now is that none of the different proposals on the table, on the evidence proposal, guarantee a systematic and meaningful involvement of even the member state of execution. The Commission, you mentioned it, Mr. Lagodinsky, it's a privatization of the legality assessment of the order. As regards the Council started departing a little bit from the Commission's approach by obliging to notify the executing state, but there are three very substantial limitations to that procedure. First, the executing member state doesn't have to check if it doesn't want to. Then it's limited to orders that are seeking content data only. And then third, the reasons for refusing to execute an order are very limited. So if an order breaches the Charter of Fundamental Rights, the executing state cannot veto it. And then for the Parliament, there was a better procedure built in the report, but the biggest improvement are just limited to traffic and content data, which is very unfortunate and unfortunately not sufficient for us. What we would need instead is that we need an explicit agreement of the executing state before the data transfer happens. If that means more financial resources for the judiciary system, so be it. Member states should take that on and fill the gap. I don't think it's appropriate to sacrifice judicial protection for cheap and fast data access. Then we need a notification also to the affected state. EDRI believes that involving the country of residence makes a lot of sense because only those authorities may know about particular protection for lawyers, doctors, etc. And then lastly, that's my last point, for all types of data, there should be a notification and validation procedure, because if you start exempting data categories that are considered less sensitive, like subscriber data, you will not facilitate criminal investigation. Identification of potential suspect is a key phase in an investigation. And yet, if the identity of a person is revealed to investigative authorities, but then we find out later that the way the data was collected was unlawful or it benefited from special protection, then the whole investigation might well collapse. I'm leaving my concluding remarks for the discussion. Thank you so much for your attention.
Yeah, well, thank you so much. And just to re-emphasize that we are talking here about the judicial cooperation principle, I would put it this way, is being injured and substituted by the usual principle of judicial trust, mutual judicial trust. How much of judicial trust can we have if the Dutch court just yesterday refused yet again to deliver on the warrant, arrest warrant by Polish authorities, because they said there is no judicial trust, no more, between kind of as a natural state of affairs between the states. I just wanted to add this as a piece of information. Let's go to fair trials and to your position. Laure Baudry, Gerard, you are welcome to take the floor.
Thank you very much.
You have the floor.
Thank you very much. Thank you for the invitation. So just very briefly, Fair Trials is a criminal justice watchdog, and we work with a network of human rights defenders, defense lawyers, NGOs, and academic institutions across different countries. And I very much echo Chloe's calls for safeguards. And here what we're saying is that we risk going ahead with an instrument that gives massive powers to law enforcement authorities with very limited checks and balances. Even though ultimately, on the one hand, this information that is being gathered may be used as evidence against a person to base a conviction and even possibly to send them to prison, which is why safeguards are in place to ensure that proceedings are fair and that any conviction is safe. But safeguards are also there to keep law enforcement authorities in check and operating within the remit of their legal mandate. And in the current political context that we've touched upon several times already this morning, it is deeply worrying that we're proposing to bypass meaningful safeguards. And our position has been that this is absolutely fundamental in the negotiations. And I would focus, just since we have limited time, on notification. So the first aspect is notification to the executing judicial authority. Now, the involvement of a judicial authority on the executing side can offer a safeguard, but that involvement, that safeguard, can only be meaningful if the authority is adequately informed by the issuing state about the reasons for this production order, and is also placed in a position of assessing the proportionality of the measure, of assessing the fundamental rights implications of executing such an order, and also that this authority has the real possibility to refuse execution. And we all know how justice in Europe is so badly under-resourced and so overused for all types of cases and situations. We're seeing it now with the COVID-19 crisis. So we're overloading our justice system and we're not giving them enough resources. And now we're giving them this, a safeguard could be giving them this responsibility, but we know that it needs to be accompanied with resources, information, and support if it's going to be meaningful. And we see how inadequate or vague wording, for instance, in the context of the European arrest warrant, when it comes to the role of the executing authorities, has meant that it's very difficult for authorities to actually exercise this duty of checking the purposes and the proportionality of a European arrest warrant, and how difficult it is for authorities to get hold of information that they need to protect fundamental rights in individual cases. But my second point around notification is that there's also the aspect of notification to the person concerned, the person who is directly affected by the measure, by the request for information, and that person is probably the person in the best position to defend themselves, to argue the fundamental rights implications of the request, and also to challenge the legality, the admissibility, to seek an effective remedy, a fundamental right in our charter. And yet, if you're not on notice, how can you get access to a remedy? How can you exercise that right? So notice is also about equality of arms, notice to the person, because we do also see a shift in our punitive systems. We're going through from an inquisitorial system where investigating authorities are deemed impartial, gathering all data to find out the so-called judicial truth about what happened, to an increasingly adversarial system where it is up to the person to make their case. So giving notice would also help balance out this information asymmetry and put the person in a position to make their case, to find the information they need to exculpate themselves. So that's, I would just like to finish off with some hope around Article 7 and Article 11 in the current proposal. And we would like very much to see this discussion not just focused about cooperation between authorities, but also to put the rights of the person at the heart of the discussions as well. Thank you.
Thank you so much for this great overview on the issue of notification, which is indeed in our in the epicenter of our first meeting today. Of course, the issues of notification, of production of information, etc., all those invasive instruments that are being foreseen now, they will have the biggest impact, of course, on certain professions that live from being protected against state or corrupt interventions. And that's why we're very happy to see that we have kind of a professional view and union of certain entities, companies, but also individuals who could be affected by that. We would like to start, I would like to start with the European Broadcasting Union and Julie Léonard, who is present here. What is your take on the situation? What are the risks and maybe the benefits of what is being proposed now?
Okay, thank you very much, and good morning, everyone. Thank you for the invitation and allowing the EBU to express itself on the matter. So maybe very shortly, for those who are not familiar with the European Broadcasting Union, so our associations represents over 100 public service media organizations across and beyond the EU. And the reason why we follow so closely the negotiation around the e-evidence proposal is because we fear that without the necessary safeguards, this regulation would enable the targeting of confidential editorial and journalistic sources, and ultimately having a chilling effect on freedom of expression. So together with other media stakeholders, and some are represented here today, we have expressed earlier in the legislative process the need for all orders to be verified and authorized by the executing authority before any data is handed over. But as you all know here, this position is not reflected within the text currently under discussion at trilogue level, and we find it very disappointing. Nevertheless, I mean, we still have hope that the trilogue negotiations could lead to a good or satisfactory kind of outcome, because the European Parliament has suggested a number of improvements that we support and thinks that they are that these are going in the right direction. And I will here just mention two points. There are others, but happy to detail them in the Q&A session. So first, I mean, we very much welcome the recognition of the European Parliament of rules related to freedom of expression and freedom of the press as ground for refusal for the enforcement of the order. Certainly this wording can be further improved, but we appreciate the fact that these freedoms are recognized in an article, but also in the recital 35, where journalists are expressively mentioned. The second point is that we also reckon that the gradual approach suggested by the European Parliament, which established different recognition processes based on the nature of the order, but also taking into account the sensitivity of the data, is an improvement to the Commission proposal, and we believe that this would help secure most sensitive data and also address most difficult situation. So as you would have understood, the EBU will stand behind the European Parliament's position during the trilogue negotiations, and we believe that the safeguards that were introduced in the report needs needs really to be maintained throughout the negotiation process, and should not in any circumstances be watered down. So this is our position so far. Thank you very much.
Thank you so much, Ali. This was quite helpful, and indeed one of the main points also for us in the parliament negotiation was to have a stronger safeguard for journalistic professions especially, but also for some other affected groups. And with that, we go to the German public broadcaster ARD, Jürgen Burggraf and myself. We were in contact on various occasions, and you have also followed the negotiations in the parliament. What is your take on the situation now? Welcome here.
Yeah, thank you very much. Thank you, Mr. Lagodinsky, and good morning to everyone. Let's recall for a second where we started from coming into the process. We were asking for a full-fledged exemption of journalistic work and journalism from the scope of application of this future regulation, and that in principle such a process is possible, is evidenced by a comparable and having taken place in parallel process in relation to the counterfeiting terrorist content online, where the result de facto is a broad exemption for material for journalistic purposes from the definition of what could be terrorist content, and thus from this respective regulation. So this is principally possible. Unfortunately, concerning e-evidence, we haven't come there. Neither the Commission nor the Council has responded to this. In that very sense, also the Parliament has not responded to it, though we must say that by the Parliament and only by the Parliament, we are witnessing important improvements that have been introduced to the process. At the same time, coming from that very principal position, I think our take on it is to say the EP position is the absolute minimum that needs to be secured, that needs to be achieved. You cannot go below this. Otherwise, you really severely or significantly risk to undermine the integrity of journalism, of journalistic work, and so forth. So that is maybe a very principal point. I would like to make 2 points from a very practical angle of securing journalists and journalism. The one thing is that when it comes to the immunities and privileges in the line of securing freedom of the press and so forth, that will lead to certain limitations in criminal law in terms of limiting criminal liability based on those privileges and immunities. But when it comes to journalism, one must say, for example, in Germany, and I think that's the case in many other member states, the respective safeguards for journalism are not enshrined as such in criminal law, but in criminal procedural law. And we need a clarification. We need a clarification in the text, either in the respective recital or in the norm itself, that the criminal procedural law safeguards for journalism are also covered by the overall safeguards as in the text. So we need that is not introducing something new, which is very difficult in a trilogue, but this is an absolute must clarification of the text. Second point, from a practical and very principal point of view, I want to make the reference for these immunities and privileges and these liability limitations and so forth is a formulation that goes freedom of the press and freedom of expression in other media. And I must say, I mean, it's good that it's there, and it's good that the Parliament has gone this way and has introduced it. But still, I'm a kind of unhappy with this formulation, because at least we should acknowledge that the freedom of the press and the freedom of the media should be put on equal footing. And that is for very practical reasons, because in day-to-day work of the written press and other media, which is mainly electronic media, there shouldn't be any difference between the different actors in journalism according to whether they write on paper or type in a computer, or they make a video or an audio or something. And beyond that very practical context, I must say that if you go to constitutional law on the EU level and the member states level, you don't find this distinction. It doesn't make sense. The European Charter on Fundamental Rights speaks about freedom of media to be protected in Article 11. If you, for example, take the German Grundgesetz, so the German Constitution, the German Basic Law, and you refer to Article 5, it even says protected is the freedom of the press and the freedom of broadcasting. I wouldn't stick only to broadcasting or understand it in a broad meaning, but for example, by the Article 5 in the German Basic Law, from there derives not only a constitutional guarantee, you can even go that far to argue that an institutional guarantee is provided by this. That is for public service broadcasters or even private and public service broadcasters in Germany. And by the formulation chosen by the parliament, for example, which is freedom of expression in other media, you would put, for example, a public service broadcaster or an established private broadcaster on the same level as, for example, a blogger who is doing journalism. Nothing against a blogger who is doing journalism. That is important, but we should respect that there are different institutional and constitutional guarantees for these. So somewhat the text needs to be better qualified in a respective form. So this is
I completely agree. Yeah, thank you so much, Mr. Berger. I completely agree. And generally, just on a very general note, I have a feeling that sometimes the complexity of the criminal law, criminal procedural law structure is not quite well reflected in any of the drafts. So, for example, when we're talking about dual criminality, and where we see that service provider should, establish whether something is being, punished in both countries. Of course, in StGB, in the criminal code, we also have the punishment of blasphemy. But there is, of course, an application practice which does not punish people about the blasphemic things, because it's a constitutional court of Germany jurisdiction, and the courts don't apply this. So there are different layers. They are not reflected quite well in any of the drafts. You talked about press versus various media, and VDZ and Alexander Nietz can tell us probably a whole big presentation about whether print or media as the representative of the magazines in Germany. But let's focus on the topic and what criticism you have on the drafts we're discussing here. Welcome, Alexander Nietz. You have the floor.
Thank you, Mr. Lagodinsky, for the invitation, and good morning, everyone. Just 2 words on BDZ, the Association of German Magazine Publishers. We are the voice of the German magazine publishers. Our members publish over 6,000 titles, both B2B, B2C, print and in digital formats. And today I'm also speaking on behalf of our European press publishers associations, EMA and EMPA, which we work closely on this. And I would like to start out by saying that, improving efficiency in cross-border law enforcement cooperation, especially in the digital age, there's value to that. We see that, but however, it cannot come at the expense of freedom, and I think this is very important. In the EU and in our Western democracy, I think the limits of press freedom are determined by national courts in application of their national laws. And this applies both to the limitations of what editorial content, the limitations of what editorial content can be, and for example, what is considered legal speech. But this also applies to the very key pillars, to the limitations of the key pillars of press and media freedom. So for example, editorial secrecy, as well as the protection of sources. The problem that we have with the e-evidence proposal is that unfortunately completely disregards these basic principles, and it actually introduces a change of paradigm. And as it has been said by speakers before, it has basically excluded from the procedure the executing authority, so the authority of the member state where the journalistic or editorial data is stored. And instead, it has basically empowered private companies, so the service providers, as well as the authorities of other member states to decide over the limits and limitations and the protection of press freedom and media freedom. We fear that such a regulation would open the door for widespread interferences in press freedom, press and media freedom, and I think this comes at a time where we see press and media freedom under attack and in decline all over Europe, and we hear about it and see about it, almost on a daily basis. So this is very concerning, and our position from the very beginning, and I think we share it with what Julie and Jürgen already said, that press and media freedom can only be sufficiently protected if the executing authority plays the decisive role in the procedure. So this means, in other words, or in more practical terms, that any cross-border order has first of all be notified to the executing authority immediately. The executing authority has to assess it and verify it according to its national standards. And very important, before any data can be issued, it has to validate the order. This is for us very crucial that these procedural safeguards are introduced. Now, of course, trilogues have started, and thank you, Mr. Lagodinsky, for the debrief of yesterday's first political meeting. We do regret that none of the three negotiating positions at the moment include those safeguards. That is unfortunate. However, and yes, the European Parliament text is not perfect either. As several speakers have said the same. It is not perfect, but it introduces some very important safeguards. Introduces some very important safeguards with regard to the involvement of the executing authority, or executing member states. Introduces some very important procedural safeguards with regard to the grounds of non-recognition, and in combination with, of course, some clarifications on immunities and privileges. And in that sense, just one word, I fully agree with what Jürgen said. It must be ensured that criminal procedural law, the protection is expanded there as well. So it cannot be limited to substantive criminal law to cover all journalistic data. So now we're facing the situation. As I said, the Parliament introduced some very, very important safeguards. They might not be sufficient, but they must be, in our opinion, treated as absolute red lines in trilogue and should not be watered down any further.
Yeah,
thank you
very much. Thank you for this re-emphasizing also to Alexander and to Jürgen, who mentioned these are the minimum standards that we have to fight for, and we should not go beyond those red lines. That's probably an important point. And with that, let's go to our lawyer colleagues. I'm happy to see you, Ulrike Paul, from the German Federal Bar Association. Please, Ulrike Paul, you have the floor. What is the perspective of lawyers, attorneys, jurists?
Good morning, everybody. And first of all, I would like to thank you very much for your invitation. The German Federal Bar has followed the developments regarding the e-evidence proposals with great concern, mostly due to the rules on direct communication of the authorities of the issuing state with private service providers that left control mechanisms in the executing state largely limited. The Commission's approach seemed rushed. We are following the trilogue negotiations now with concern, as we consider also the position of the Council to be far from sufficient. The most severe problem lies in the marginalization of the protection of the fundamental rights of the persons affected. The draft regulation shifts the responsibility almost entirely to the issuing state. Also, experiences with the European arrest warrant, for example, have proven that at least some control in the executing state is urgently needed. Unfortunately, not all member states ensure a sufficient degree of rule of law standards and protections of fundamental rights, including protection of the lawyer-client privilege. I think that's really a big problem. Speaking of the lawyer-client privilege, during the legislative process, we were very concerned there will be gaps, for example, in cases where the lawyer and his client reside in different member states. We welcome the compromise that the committee has found in Article 5 on conditions for issuing a European production order, which refers to the law of the member state where the person whose data is sought resides or is bound by an obligation of professional secrecy or lifetime privilege. We do, on the other hand, regret that the authorities of the country of residence of the person whose data is sought are not involved or do not need to validate an order. Really big problem. The country of residence of a person normally is the place that is most suitable for the protection of a person's fundamental rights, and therefore also knows about whether there may be a case of a lawyer-client privilege. We are afraid this will lead to an insufficient protection. Finally, I can say that we would have preferred the introduction of judicial control in the executing state or at the European level for all orders. But since this apparently is not doable, we now support a notification procedure accompanied by a strong right of objection of the executing state before a production or preservation order can be executed to ensure the protection of fundamental rights of the affected person. Thank you.
Thank you so much for this overview of your perspectives on that. Very useful. And let's complement that with the German Bar Association perspective and the final participant today, Dr. Anna Oemmichen. Welcome here. You are an association of German lawyers, also working very actively in human rights issues, etc. What is your take on the situation? You have the final floor in this round, and then we will open to a very brief discussion.
Well, thank you very much for the opportunity to participate in this discussion. A lot of important points have already been raised. The German Bar Association is very grateful for this opportunity to speak about this important topic, a topic that has somehow remained rather unnoticed by the general public, but will nonetheless have an extremely high impact on fundamental rights. The report by the Parliament has taken on several aspects that can be welcomed from our perspective. For instance, the requirement of an explicit written approval when it concerns orders that have been issued by a state that is subject to the Article 7 procedure, rule of law procedure. This is necessary to ensure that orders to obtain evidence are not abused for illegal purposes, for political reasons, etc. However, there, at least, and again, like my predecessors already mentioned, we are here discussing the real minimum of what needs to be done to preserve a minimum of fundamental rights in the present position. So the three issues that we're particularly concerned about are the following. First, the judicial control in the executing state. We are very concerned about the lack of judicial control of orders that are directly addressed to private service providers, which are not in the position to assess the legality of an order. The main argument against a higher level of judicial control seems to be that this would contradict the idea of a rapid and swift transmission of electronic evidence. However, the end can never justify the means. The loss of time cannot justify lowering the level of judicial control, which is one of the cornerstones of the rule of law and fundamental rights. It is therefore necessary, in our view, that not only in the issuing state, but also in the executing state, a judicial control is mandatory for each order. Outsourcing this control to private actors is not only inadequate, but actually dangerous because private actors follow different interests. Our second point concerns the factual basis of the orders. In the current draft, there's no statement of facts in the European preservation and production orders. It is argued that this is only for data protection reasons. However, we consider that both European preservation orders and European production orders require the issuing authority to provide a brief summary of facts when issuing the order. Why? Because this is a prerequisite for anybody looking at the order to be able to assess the legality. If you don't know the facts, you cannot see whether the facts justify the order and whether they comply with the legal requirements. Similarly to the European arrest warrant or the European investigation order form, the fact should at least include a description of the circumstances in which the offense was committed, including the time, the place, and the degree of participation of the person concerned. Following the Parliament's report, the issuing authority is required to provide information on the necessity and proportionality of the measure. This is good. However, this can also only be reasonably done by outlining the facts of the case. Therefore, it is our position that the text should include a direct reference to the facts. And our last point, but for lawyers, and not only for lawyers, the most important, is the implication that this e-evidence has on the legal privilege. We also have to look at the safeguards put in place to ensure the confidentiality of the lawyer-client privilege. The lawyer-client privilege is one of the fundamental cornerstones of the right to effective defense, and effective defense is protected by Article 6 of the European Convention of Human Rights. It must be ensured that when data are requested, no privileged information is accidentally gathered as well. This is also a requirement by the Court of Justice of the European Union. In its recent decision on mass data retention, the Court of Justice held that data retention may deter users of means of electronic communication from exercising their freedom of expression, in particular in cases where communications are protected by professional secrecy. This becomes more important every day as cross-border investigations force clients to engage lawyers abroad, with the consequence that private personal meetings are often impossible, also without the corona pandemic, so that they have to rely on written, confidential communication.
Yeah, that's
the
absolutely
Parliament report
important.
mentions the lawyer-client privilege for European production orders, but not explicitly for European preservation orders. For the sake of legal clarity and certainty, we therefore propose to include a reference also for the latter. Thank you for your attention.
Thank you so much. So those are important points. They're on the table. Let's use the remaining 10 minutes maybe to kind of debrief between each other. I know that Chloe wanted to say something, to add something to the discussion, if I'm not mistaken. If I am, tell me.
No, you're not. But I just wanted to re-emphasize some concluding remarks. I just wanted to echo the call from SEPS, which came as a surprise in October, but we were very fond of this call to actually withdraw the proposal. We believe there is much work to be done on evaluating the existing judicial instruments, notably the EIO and the Mutual Legal Assistance Treaty. We believe this is the only way that we can have efficient cross-border access to data for law enforcement in an efficient way, and also safeguarding fundamental rights. So that's very important. I might take this opportunity actually to just launch the debate about the difference with the terrorist content regulation. I found it very interesting from Mr. Bogaf. I wanted to signal, though, that the terrorist content regulation is not really an example, a good illustration of how to protect freedom of the press, because even though you have an exemption at the definition level for journalistic content, so it's out of the definition of terrorist content online, it doesn't really follow into concrete steps afterwards in terms of procedures. So you have cross-border removal orders, and there is lots of limitation on what the executing state can actually do to refuse a removal order. And even though even worse, actually, the removal order has to be like complied with within 1 hour, which is even like less time than the production orders. So I found the comparison very interesting, and I'm happy to hear more about your thoughts and why you wanted an exemption in the evidence if it's not then followed by concrete procedural safeguards.
This was a question to.
Well, actually, I think my
to Jürgen, right?
Yeah, you're right.
Okay.
I see the point. No, I see the point from a legal or legislative point of view and your respective criticism. I think my point was simply on the political process that led to what has been then the outcome in the trilogue. Because in the very beginning, our position, again, it was about fully exempt journalists and journalism. And for good, the parliament adopted this position. They also said, let's have them out of the scope of application. And the political process, with all its flaws in legal terms, and you have mentioned them, nevertheless led to something like an exemption. Let's put it this way. And my point or question was simply, why not in political terms comparable process be a bit more ambitious and go there? It is principally possible, or it would have been principally possible. Now it's not anymore because the grounds for going that far are not laid in the trilogue anymore.
Just if I may add something, it is not unthinkable that if we exert enough pressure, there will be added certain issues or safeguards which weren't in neither of the drafts. So in terms of strategy, I would not discourage all of us to inject important additional information if it is framed with with enough political and public pressure. Alexander, you wanted to mention something.
Yes, no, thank you, and I think that's a good point. And I think one issue, and besides the point on limited criminal liability, which was mentioned by Jürgen, the case, and which I also reiterated, I think another important issue, and I think it was mentioned once by another speaker. Apologies, I don't recall anymore who it was, but I think it would be of utmost importance to ensure that the final compromise doesn't differentiate between the types of data. So that all types of data, and in our case, all journalistic data, requires or deserves the same high level protection. I think this is very important. Of course, content data on a first glance seems more sensitive, but when you look at, for example, the disclosure of informants or whistleblowers, exactly, so protection of sources, the disclosure of identity, with the possibility to ex post delete that information in practice doesn't provide any safeguard, and it actually puts people's life in danger. You can't put so I think
Sorry.
No, I just want to say that in the parliament there's also this differentiation in the procedure, and I think that would be important to have the same high level of protection.
This was one of my criticism of within our negotiations, because we indeed, and maybe for the viewers, we have a different way of dealing with whether this is about the address issue or the name issue, or about the content, right, or the traffic data. They are protected in a different way. If it is just about the name of the person or identity of the person, then the information will not be, according to the proposal of the parliament, this information should be almost immediately conveyed to the authority abroad who wants to know who is the person behind the name, let's say on Facebook or whatever, Twitter. And then if the executing authority ex post decides that this request was not okay, then the issuing state is not allowed to use this information. I'm sorry, they already know who this person is. So we have disclosed already the identity of the source, for example, etc. So this is one point where I disagree even with our parliamentary European draft, and I think this would be worth fighting to correct this in some way or another during the trilogue negotiations, even though, as you already said, our proposal is much better than the parliamentary proposal is much better than the council proposal, and we have the red lines there, but we still can aim higher, right? As Ms. Obama is saying, if they go low, we aim high. I think that we have collected a lot of various perspectives. Some of those we already know because this is not the first time we discuss these issues, but we have a different context now. In this context now is a context of negotiations with the council. I would urge everyone, also our public, you know, the audience who is hopefully watching what we're talking about or will be watching, to exert and increase pressure on your governments, because the governments are those who will, at the end, decide on whether to agree or not to agree to those quite invasive changes in their criminal culture, criminal procedural culture, criminal content culture, etc., etc. And those changes are there, and they will be there no matter what, unless we have alerted our home public, domestic publics, and domestic governments to watch very closely what kind of sacrifice and changing we would like to have. So I would like to close this meeting, this very interesting exchange, and thank everyone who was here. I take a lot of motivation and support with us into negotiations, and I hope that you, our guests and our viewers, also have gotten some thoughts and motives now to be active in this area. This is not a technical issue, what we're discussing here. This is important to know. People don't get it. It's e-evidence. People think, oh, this is just a minor detail in the criminal procedure. This is about our data. This is about your data and the data of everyone who is watching this video, and how easy it would be for a prosecutor from abroad whom you don't even know and in a procedure you don't even know, to get your data obtained automatically without your home country authorities even having a glance at them or doing anything against that. And I think it is about all of our rights, and it is important to activate our watchful eye of the audience on that issues. Thank you very much. We will continue with that, and hopefully we will then discuss other issues which is upcoming, not just the issues that we discussed today. I hope for your support, and hope to see